Okay, and welcome back to our AutoTalks. We are now in the first official day of lockdown, and many of you out there we know are major employers, and you will have lots of questions about what you need to be doing and what you can be doing with your team to protect themselves and also to protect your business. So our first speaker today is Catherine Stewart. Now, Catherine Stewart is a highly regarded employment law specialist and barrister. And she's going to answer a few questions for us about what you can expect and what you can do through this process. Thank you for joining us, Catherine.
Thank you, Richard. Good morning.
Good morning. Now, I just want to preface our discussions today by making it clear that we're doing this from the point of view that we would like people, where possible, to put keeping their staff on and keeping them paid at the forefront of their minds. But we're aware that that won't be necessarily possible for everyone. And we also, I think, should mention that this doesn't necessarily replace the need to go and get your own professional advice for your specific situation. Now, what are employers' legal obligations to staff during the lockdown if they can't work? I mean, are you required to pay them? Can you make them take leave? I've seen a lot of discussion online about people being asked to take leave.
Well, Richard, it's a labyrinth of lots of issues around leave. In terms of your last question, yes, you can require them to take leave. You can require them to take annual leave, but that requires a 14-day notice, and most employers have run out of time to do that, I imagine. So if they're on lockdown now and they can't work, theoretically you are obliged to continue paying them, yes, but there are options available if the employees agree to them. And so options would be, for example, they might consult with the employees who might agree to take their annual leave now. They might agree to take unpaid leave. So it's going to very much depend on the employee's agreement to take some form of leave at this point. Otherwise, there can be issued a 14-day notice, and employees can be required to take their annual leave. The other option might be special leave. So that's just a sort of a special agreement which the employer and the employee might have to agree to paid leave if the employers can afford that. And in this current environment, there's probably not likely to be a lot of employers who'll be putting their hands up for that one.
Now, if you've managed to be, if you've been lucky enough to get the government's employment subsidy that they've put out there, the wage support, is that the only money you're required to pass on to your staff, or do you need to top that up to meet their full wages or 80% of their wages? You're in a situation on that?
So your obligation as an employer, unless you've changed it by one of the examples I referred to earlier, by way of annual leave or unpaid leave with the agreement, or by way of the notice, the obligation on the employer is to continue to pay the full salary unless they get an agreement to the contrary from the employee. So what would happen in the case of the wage subsidy is that would be applied for through the ministry, and that would be paid to the employer, who would then pass that on to the employee. Now, it may be that in some circumstances the employees will agree to having their salaries reduced to that wage subsidy, and most employees are probably going to be fairly realistic in these circumstances. They want to hold on to their jobs, so I imagine there's going to be a number of employees out there who will agree to have their wages reduced. But in the absence of that agreement, the default position is that the employers must pay the full salary unless they terminate the contract, which is kind of the next last resort option for them if they just can't pay. So under the contract, there's an obligation to pay the full wages. That can be softened by the employer receiving part of those wages through the government, through the wage subsidy. But unless you've got agreement from the employee to otherwise reduce the wages, the obligation continues to pay that full wage.
If you simply can't afford to pay the wage or the full wage, I mean, what are your options? I mean, do you have to terminate the contract at that point, or could you negotiate with staff to defer some payment? What do you feel are the best options there?
You can negotiate with staff, and look, I have to stress that in these uncertain times, negotiation is the best tool, and communication is going to be your number one option, good communication with staff and communicating early and communicating well. If there's just a deadlock and it's just not going to work out, then there's going to be a restructure and redundancies which are going to occur, yes. And that's kind of the last resort option, and that's where we get to in terms of a legal perspective. If you can't continue even with the government subsidy, even with the client, even with, the employee's agreement, then the option has to be termination of those contracts. And that's something that unfortunately we're certainly feeling a lot of costs about, because it's an option that many employers are having to seriously consider at the present time.
And so when you say redundancy is the next step, I mean, what is the situation with termination of contracts at the moment? I mean, is it simply you can terminate contracts? Is there some kind of force majeure in place because of the unprecedented nature of the situation, or is it a normal redundancy process?
So force majeure is a special type of clause that some employment contracts have, which effectively says that the contract can be cancelled in certain circumstances. It's similar to a possible business interruption clause. If your contracts have those clauses, then you need to look at them really carefully and see what they say, whether they cover this type of scenario. If they do, then you possibly have a way out. It's a relatively high threshold to invoke those clauses. You need to probably get some advice around whether those clauses do apply. There's also a high risk option of frustration of contract. So as you've pointed out, this is an unprecedented situation that we find ourselves in. It's just extraordinary in employment law. So yes, possibly there's an argument for frustration of contract. It's a high risk option, I would suggest. Failing having those types of clauses, or invoking some kind of frustration of contract option, your obligation is to follow through a good faith redundancy process. And that's going to involve consultation with the employee. It's going to involve seeking their feedback, giving them sufficient information about the financials of your business so they have the opportunity to comment on those financials and have some input into it. Subject obviously to commercially sensitive material, which doesn't have to be produced, but otherwise there's quite a high obligation on the employer to produce information so that the employee is in a position to be able to comment on that prior to any decision being made to terminate them. And so, termination will apply in those circumstances, and a normal redundancy process needs to be followed through, which will involve, it's quite interesting in these times because usually it involves meeting with the employees, with their support people. So I imagine there's going to be a lot of Skype meetings being held, and Skype meetings or Zoom meetings with employees in relation to the possible restructuring redundancies of their positions. And then of course their support people will need to appear by Skype as well. So it's a whole new world of technological meetings out there.
Would it be good to say that redundancy process is another opportunity to perhaps look at negotiating a way to move forward without redundancy, not just being an option to simply end the employment?
Absolutely, yeah. Because that's ultimately what this process is all about. That's why we have it in law. It's an opportunity for the employer and the employee to sit down and work it out. And the employee, if they're going through a restructure or redundancy, will be in no disillusionment about the fact that their job's on the line. So they may prefer to look at other options which they can agree with. Maybe they reduce their salaries, maybe they reduce their hours. They can agree any manner of things that are going to keep the business churning through and keep them employed during these challenging times. So yes, absolutely, this is an opportunity for other options to be explored.
I'm going to throw a slightly different question to you. Sorry, it's one that we hadn't prearranged before, but I do understand from some situations there's been people who have been put at home by the lockdown who have then picked up secondary employment with an essential service. For example, workshop staff who've gone off to work at a supermarket temporarily. Does that have any effect on your liability and requirements to pay your staff during that period?
It would certainly have an impact on whether you should be paying them if they're not working. If you're paying them full wages and they're working somewhere else. Secondary employment isn't outlawed, so it's possible that can be worked through. In those sort of circumstances, in good faith, those employees should be telling their employers about what they're doing, and being upfront and honest about it. And in terms of paying them, it would seem like they're getting a bit of a windfall if they're not working for the employer, still receiving money and working somewhere else. So I think that would not be okay. And I think in those circumstances, it's another question of communication between the employer and the employee. So the employee is saying, you know, I'm going to do this, I'm going to work elsewhere so that I can keep my skills, I can earn a wage. But no, I don't should be paid by the employer during a period that they're working for someone else and receiving money from someone else.
Now, you've gone to the absolute extreme of having to make people redundant or go through a redundancy process. Now, obviously, that means there's going to be entitlements that have to be paid out. What's the situation if an employer is in such a poor position that they can't pay out those entitlements during the lockdown?
If they can't pay out the entitlements, they're theoretically in breach of the contract. So the entitlements will depend on what the contracts say. So you've got your statutory entitlements, obviously, which are holiday pay. That must be paid. That's no contracting out of paying that. Then you've got your contractual entitlements. Now, some contracts will have a contractual redundancy clause, which will mean you'll need to pay out some compensation. Some won't. Some will say no redundancy compensation. They will all have a notice period. Might be 2 weeks, might be a month, might be longer. So that's also a contractual obligation to pay those. Those are debts owing and due, and they must be paid. And if you can't pay them, I guess you owe a debt to those employees. You might want to try and enter into an arrangement where it's paid gradually, or, you know, however you can do it, drip feed or whatever. But in theory, they need to be paid, and they need to be paid according to the contract and according to the time of the contract. I mean, the most draconian option, obviously, for companies, and I hazard to suggest this, but this is the reality, is that some companies might go into liquidation. If that happens, then those obligations remain, and there's some priority given to the holiday pay, for example. But that would be something that would be worked through with a liquidator in terms of the debts that are owing in terms of holiday pay and wages. But yeah, they are legally obliged to be paid. Now,
we get through this period and the restrictions start to come off and business commences again. If you have had to go to that extreme of cutting staff numbers, what's the situation with bringing them back on board? I mean, can you simply restart their contract, or do you need to bring them on a new contract? What's the rule around that?
So it depends on what you've done with your employees. If you've terminated them, then you need to start a new contract. If, on the other hand, you've simply agreed that they go on leave, for example, unpaid leave for a period of time, then their contract remains on foot. So you then can negotiate with them when that leave finishes and when they come back on board. It's all open to the employer and the employee to reach agreement on those things. So it depends on what action you've actually taken. If you've terminated them, you need to start a new contract. And you've got to bear in mind here that if you've made them redundant and for justifiable reasons in relation to your finances, and then you turn around maybe 2 months later and you seek to re-employ them, you're actually undermining the justification potentially for making them redundant in the first place. So you've got to be cautious about how that's done. So, and these are such uncertain times that no one has a crystal ball. No one knows what's going to happen in 2 months or 3 months' time. So I suppose, you know, that would, on the other hand, that would be something that the employer would argue, that they couldn't have foreseen that they could re-employ them. But if you are making them redundant for genuine, you know, bona fide financial reasons, then they should be able to be proven and justified. And there's some query in my mind about whether re-employing them might undermine that justification. But in any event, yes, if you've terminated them, you need to start again with a whole new contract. That contract over, you need to renegotiate it right from day one, right from the beginning.
Just in summing up, I get the feeling that the easiest thing, or the first thing that any employer should be doing, is being open and talking through any issues as early as they can with their employees, so that we can avoid having to go to some of these extremes.
Absolutely, that's the number one message. There's no substitute for good communication. So if you see yourself getting into trouble, or you see things becoming problematic from a financial perspective, talk to your staff, tell them what they need to do in order to keep the business running from your perspective. Give them clear guidelines, whatever that might mean. This is what we need to do. We're in this together, and hopefully we can pull through. But if we can't, then things we talk to you about. I guess some employers out there might be saying, well, that's all very well, but I haven't got time because I'm just in this situation right now and I just have to close, and understand that might be the situation for some employers. On the other hand, they should still seek some legal advice around that, because what they don't want to happen is to see themselves in a worse situation with legal claims and personal grievances because they didn't actually consult properly, or they didn't allow the employees the opportunity to have representatives. There's no substitute for that redundancy process unless you get agreement, unless you agree on a parting of the ways, which is signed and sealed and bulletproof. Then you've got those redundancy processes, you've got those termination procedures that need to be followed, and you might end up in a worse situation with legal claims and personal grievances. Yeah, so look, communication is number one. Talk to your staff. Hopefully the message is out there. We can hopefully pull through this together if everyone agrees on a good way that we can all compromise in the meantime to make this work.
Fantastic, Catherine. Look, thank you so much for talking to us today. For the viewers out there, I'm going to put Catherine's website address down at the bottom of this video, and feel free to obviously get in touch with her or your own legal advisor for any further questions or issues around this. Thank you so much, Catherine.
It's a pleasure. Thank you.